sort of ellipses that are there are just an indication that we had the sort of the bench conference outside of the room. So
on page 24 with the objection, I think the statement that led to the objection should be out since the objection had been sustained. And so that we should just take out everything from line 21, page 24, line 21 through back to where the court comes back in on page 25, all right, Ms. Leos. Because part of it was the implication, and since it had been sustained, that I think it should that portion of the record should just be taken out of the transcript that's provided to the jury.
And Your Honor, had Mr. Marshall said motion to strike the question, it would be a little different situation. But Mr. Marshall did not ask to strike the question, so the question should stand.
yeah, I think that I sustained it. I just don't think we can strike it without that. And I don't think there was an answer.
Well, the part that I don't understand, Your Honor, is why is the question still relevant? Because the defense was warned that the question itself was an unethical question and shouldn't be asked. So why are we still leaving that unethical question in the transcript that we're providing to the jury?
Because that's the record, and it's an accurate record. And without it being stricken from the record by this court's order, it's part of the record. And if we were standing here in front of the jury and doing that, they certainly could see it by video. They heard it, they saw it. It's part of the record, Mr. Marshall. It stays.
And Your Honor, then I'd move to strike it now. There's no, I mean, it hasn't been presented to the jury, so at this point, there's no difference in moving to strike now than moving to strike then. Because they'd heard I can't take away what they would have heard at that time, but we still have the opportunity to take away what's presented.
I think it's a bit untimely, Mr. Marshall. Mr. Carter.
It's untimely, Judge, because in the record, the transcript, which is going back to them as part of the record, was different from the video records or the video they saw. So it's untimely, it's inappropriate. This is the record; it should stand as presented.
It is untimely, but we deny it.
And just, Your Honor, for the record, at what timeliness, the objection was made immediately after we started talking about the transcript.
Well, I understand the objection's fine, and it was sustained, and there was no answer given. There was no request to strike it from the record, and I probably would have done so at the time, but it wasn't made. This is untimely.
Okay. And Your Honor, the other question, problem I saw was with the jury instructions. I think the way that they're presented is not logical in a sense, and I'm wondering if we should do them in a slightly different fashion. Because we have, and I think the way, I think it might be more confusing to the jury the way we have them, because we have the top count one, and then the alternative top count one, and then the lesser included, and then the lesser included. I think the lesser included should follow the count that it's attached to, because it seems to make a little bit more sense that when you're looking at it, you're going from count one, and then the lesser included of count one, and then the alternative of count one, and the lesser included alternative of count one. When we string out the lesser included after the alternative charges, I'm afraid it is a little bit more confusing to the jury, because it's less clear which count those lesser included is attached to, because there's another instruction in the way.
Well, the negligent cause and negligent permitted are not lesser includes of each other. I don't think they're different degrees, correct? The intentional, of course, are. So I'm not sure I understand what your confusion is, and I don't have a proposal yet in terms of how we change those. Let me hear that.
And it's regarding for count one, it's the intentional, and then it's the language placed in a situation which endangered life or health. Then it moves on to the alternative of count one, which is the intentional, tortured, cruelly confined, cruelly punished. Right. And then it moves on to the lesser included of count one, which goes back to the place in a situation which endangered the life or health. Mm-hmm. And so I think that both of the ones that talk about placed in a situation which endangered life and health, since they're attached to each other, I think it makes more sense for them to flow into both the jury instruction and the verdict forms that way. Mm-hmm. And then also then the alternatives that way, just so it's clear what it is truly a lesser included of. Because the way it's currently reading, it makes it sound like the lesser included of placed in a situation which the recklessly caused or permitted placed in a situation which endangered life or health is actually a lesser included of the tortured, cruelly confined, cruelly punished intentional charge. And I think that's just, it's a little misleading the way it's done, and it could be just cleaned up if they were kind of following the appropriate counts.
Where do you propose to put the 141 instruction in that, to make it clear? Because that
The general
that has to
intent
follow.
instruction?
Let me finish. That has to follow the intentional elements instruction, right? So to make it clear what to apply to. So tell me what your proposal is. So you want to put the reckless disregard caused in permitting placed in a situation behind the intentional, and then you want to put the intentional tortured, cruelly punished, and its reckless and sort of the step down negligently caused after that intentional elements instruction, and then where do you place 141 and the step down to make it less confusing?
I think we would essentially be taking, removing the current placement of the alternative to count one. Then you would read the 141 instruction, then the lesser included instruction, and then you would move that alternative count to the other, to just place it right in front of the other count that also corresponds with tortured, cruelly confined, cruelly punished. I'm not opposed to having the general intent instruction after both intentional counts, but I think we could easily copy that and include that if that's the concern of the court.
You want a 141 for each one of the intentional counts?
I mean, I think we can tell them that it tracks with each intentional count, but if the court's, I was just saying, as a proposal, if the court was concerned, we could have it follow.
Well, I am concerned, because I think they've got to apply that to those two counts, and I don't think they want to necessarily apply those to the negligent counts. That's why I put it where I put it, so that it would track those two intentional counts, and then we move into the lesser included negligent caused and permitted. So I guess that's my logic. Whether it's sound or not, I guess that's just my logic.
And I think then my concern, I mean, if the court wants to do it that way, either way, there's going to be a little bit of ambiguity, whichever way we do it, Your Honor.
A little bit, Mr. Marshall.
But I think with the verdict forms, at least, we could do it in a way that it is count one, lesser count one, then the alternative count one, lesser alternative count one.
Yeah, I mean, I think the way we have it with the step down at the end of that count to sort of instruct them how to treat that count is appropriate where it is. I guess I'm just a little concerned about putting interspersing the lesser included negligent cause and permitted counts between the intentional counts. To me, that's more confusing to me as I read them, and I've got a simple mind, clearly, and I'm trying to think about how the jury's going to read these and make sure that they're clear with it. So that's why I did it. Mr. Clark, can we hear from you?
Judge, I believe your discretion, but when you say negligently caused, you're referring to the reckless.
Recklessly.
Oh, okay.
That's right. I'm sorry. Yeah, you know, I
It's hard to.
can't get out of that mode. I'm sorry. You know.
No, I just wanted to make sure. I can't help but feeling there's an ulterior motive to anything the state asks for, but I apologize for that, but I agree with the court that this is as clear as can possibly.
Well, yeah, thanks. I mean, I'm trying to make sure that when they read it, it's going to be confusing. And I don't think we're going to be able to avoid that with the number of alternatives we have and the step downs and all those things. But I think in terms of reading it to address, and the reason I again did it, Mr. Marshall, is because the step down sort of chronologically treats it that way. Let's talk about the intentional counts first, and make a decision about those. If you find there's no intentional child abuse here, then we're going to put those to the side and decide that they're not guilty of those. Then we're moving on to the reckless disregard counts, and I thought it just sort of fit the way the step down is drafted. So you know, it probably doesn't really matter. It's probably not really a legal issue. It's sort of logistical, pragmatic issue. You have some strong heartburn about it.
No, Your Honor, I think it is a preference issue. I do think because there are so many different instructions that that relate back to the different instructions, it's hard to then have them kind of in a linear fashion. They're all going to be clustered in some fashion in one way or the other. I do think, though, it would make the most sense for the verdict forms, though, to flow the way the state was proposing. To have the lesser included to immediately follow the counts instead of the way the jury instructed.
Sure, and that's fine. I don't have any problem with that. Speaking of which, I don't have the verdict forms, so I'd like to see those if you have them, please.
Yes, Your Honor. And I think that's the change that needs to be made, because I think the verdict forms that I currently have are the correct ones. The way that were originally proposed versus the way the state is now proposing.
Well, let me see them. And Ms. Clark, Ms. Less, have you seen the verdict forms?
No.
Why don't you show them the verdict forms as well, and then bring them up to me. I don't want this jury waiting down there too much longer before we get this going. We do have to make copies of the instructions. You know, I don't, Mr. Marshall, I really don't, it doesn't really matter to me if you want to put the reckless disregard placed in a situation after the intention. That doesn't really matter to me. I mean, it'll read either way, frankly, as far as I'm concerned. So, is there any difficulty from the defense side?
Judge, if talking to the court, I don't know that it makes a terrible amount of difference.
So I'll do that. Then I think if we do that, then we'll do that for the tortured, cruelly confined or cruelly punished as well. So, and then after that, we'll put the general intent instruction and then the step down to follow. Mr. Marshall. And we'll do that on both count 1 and count 2.
And Your Honor, I had a chance to look at the verdicts, and I don't see any problem with verdicts.
Okay. Would you hand those up to me then? We'll just leave them in the form that they are, in the order that they are.
The order was okay.
Well, the concern I have, I think, is
It's just the final draft. Alternative to lesser included in the form.
well, okay. I just think the order is still off. Is in the way that I showed defense counsel, and I can switch the order to the way the state's proposing, but
Now, that doesn't make any sense, because the way these are numbered, you have the top count, and you have the alternative, and you have two lesser included on count 1 and count 2.
Let me see them.
And that seems to make sense. They're four options on count one and count two. That seems to be the proper order.
Well, you know, again, I think it's 6 of one, half a dozen of the other.
Is the way the state proposing that we do the alternative counts first and then the lesser included? Is that what, Mr. Dick?
Yeah, herein lies the problem with the lesser includeds and the alternatives. I think what you're proposing is that we have the verdict forms in the same order that we're doing the jury instructions. Is that what you're asking for?
Yes, Your Honor, because the intentional count should go first, and then the lesser included should follow it. Because the way we're instructing them is that they obviously have to consider the top intentional count first, then they can consider the lesser included that follows that count, and then they can still consider the alternative count and the lesser included independently of their decision with the other alternative count. I mean, they still have to go top down. But I think by putting the two top counts and the two lessers, it might be slightly confusing that they're supposed to look at the intentional count, then the recklessly as part of placed in a situation, and then the intentional, and if they can't make a decision, then they move down to the lesser included of recklessly caused for the torture included crime.
Well, it's going to follow the instructions, Mr. Clark.
And it's an academic question because the jury theoretically doesn't know the difference between the counts and level of severity. Just so long as we're not going to cause more confusion, and just so long as the two track each other, I guess we're fine.
I am afraid that there's not going to be a great deal that we're going to do to not cause some confusion with this poor jury. I think we try to lessen that as much as we can, but maybe it would be easier to follow if the instructions are going to be changed in the way that you're proposing, to have the verdict forms do the same. I guess we'll find out by the questions that we get. So let's do it to track the instructions. We'll have the verdict forms to track that, and we'll see how they do. All right. Shot. See how that works. So let's take a brief break. What I'll try to do is let's get the instructions ordered in the way that we need. Give you a chance to take another look if you need to of the transcript, and we'll be back. We'll get the jury in just a few minutes once we get the copies made, and we'll get started. Before we take a brief break, the other instruction we received at Ms. Laos, that's UJI 145111. Is that the one that you sent,
No,
right? Well, it should have been 5110.
5110, Jerry.
Yeah.
I can revise that and send it off.
Well, yeah, we need to get it on the record. We were going to do that this morning, but I didn't want to do that with the version that you provided. So if you could get 5110 sent over to Sonia, we'll get that, and then before we bring the